Cabarrus County School District is facing two lawsuits this morning. The first case involves a former J.M. Robinson High School teacher accused of restraining a student with special needs by sitting on him and allegedly choking him. The alleged incident happened in October of 2024. The family claims the district was negligent in ensuring their son's unique needs were met and that the former teacher violated his rights.
Now, the second lawsuit surrounds a woman who claims she was denied a position with the district due to her race. That teacher alleges that she was offered a position before it was then rescinded and given to a white person she says was not equally qualified. We have reached out to the Cabarrus County School District regarding both of these cases and have not heard back yet.
Joining us now, our Chief Legal Analyst, Khalif Rhodes. Khalif, I want to start with the case that Jason first brought up there. How hard is it to prove one of these where you're saying, I'm qualified, the person who got the job isn't as qualified, they got the job over me and they're a different race, and I'm part of a protected class? Understand the argument, but how do you prove it?
Yeah, I like that, Julian, that you've been paying attention, talking about protected classes. He may have taken some law school on the side, it sounds like. But that is the main portion that we'd have to address. Was this person, was the discrimination not based on performance, but was it based on race? And that's really what it will boil down to. I've participated in a number of these claims in the past, and it's trying to figure out where the discriminatory act alleged began and ended is always going to be the hardest part. It's clear that there was some discrimination for most of the cases. You can see, okay, I wasn't promoted, I was removed, I was given, I was demoted. Those things are easy to see on his face, but the basis of the discrimination is not as easy. And so you're looking at text messages, you're looking at emails, you're looking at any communications that they've had with the individual, you're looking at any performance reviews at one person versus the other, and you're seeing, well, do you have any type of pattern do you have a history of not promoting individuals that are in this protected class? I mean, so you're just going back and looking at the things that are there, and then if it presents the case to support the argument that it was a decision that was based solely on race and not on something else, then this is basically open and shut. I had a similar situation like that with a cafeteria worker where she was discriminated and it was based on race, and a lot of law firms didn't see it. And most of the time, I mention this often, that when you get to file a claim in federal court, oftentimes they get dismissed, motion for summary disposition, or a motion for B-12 to get it kicked out because you failed to state a claim or because the case is barred. We made it past summary disposition. We made it past a 12B6 motion, and I can say that claim, they had a number of facts to support that this woman was being discriminated based solely on her race, and a lot of it was emails. It was communication that was behind her back that was making derogatory statements about her and how they would not allow her to be promoted based on that.
I want to go back, similar to how you just mentioned that case, trying burden proof evidence. What do you have to show? Let's go back to the first case. When you've got a possible nonverbal child or cognitively impaired somehow, how do the plaintiffs, what is the evidence, the burden of proof, when you're trying to say, hey, this is what happened to my child? If you can't ask them or if they can't communicate, what does that look like?
This is going to be obviously a harder one if the individual is nonverbal, but I mean, it's just like I mentioned with the tort claims in the past, the duty, breach, causation, and damages. In this situation, the damages will be the hardest portion to prove. And so when you're looking at the damages, you see that they talked about the individual now having PTSD, going to seek treatment. So I talk about how it can't just be an emotional harm, but the emotional harm now has to manifest itself into some physical type of harm. So if you're seeking treatment and you're not getting to rest and you're staying up all night, you're having nightmares, those are the types of things that you can point to as what my damages are, your damages are. But then, did you have a duty, and have you breached that duty? You can point to, in this situation, that IEP, that individualized that plan, that's supposed to be followed to the T. There's no exception, there's no deviation. They draw the roadmap for the teacher and everyone in the school. For any person that has an interaction with that student has to follow that IEP plan. And if they fail to, there are consequences, and that's why they list that as one of the reasons for their complaint as a rationale for the basis of them saying they've been wrong. Specifically, in this IEP, the kid was not supposed to be touched and given an opportunity to calm themselves down. You insert new teacher that doesn't understand or doesn't appreciate the ramifications of violating the IEP. Well, that's what I would point to in the complaint, and that's what they're listing here as the reasons for why they feel like they were violated. Also, failure to follow up on the IEP plan and failure failure to properly train staff. So in this regard, the nonverbal portion of the student does make it hard, but the facts will just be there. Like if the teacher wasn't aware, wasn't properly trained, wasn't properly brought up to speed on this kid's individual treatment plan, and they'll have to show, yeah, we had a meeting on 8/15 about this individual, this teacher knew it, going forward, if the school district failed to do that, this is pretty straightforward.
Khalif, a little bit of a curveball possibly, but with these school districts in both of these cases here, do you think there's any willingness when you have a school district to settle out of court rather than have this be prolonged, be in the headlines and news and have this repeatedly out there? Or is it easier to say, these are the facts, this is what we're willing to offer, can we kind of put a bow on this?
Sometimes, so for the employment one, right, with the failure to promote and based on race, those ones you see the settlement oftentimes a lot sooner. When these ones that are involving kids, you do, but the school district will say that they're immune first. So they'll fight and say we're protected, at least in this school situation with the kid, that we're protected from the negligent actions of our employee. I've talked about that before, that respondeat superior, that typically an employer can be held liable for the actions of their employee if it's within the scope of their employment. Well, if this teacher was going outside of the scope of their employment, trying to restrain the student from leaving, well, I'm sure they have a resource officer and a number of other individuals that do this. And so I would point to, or if I'm the school district, I'm saying, hey, that wasn't in their job description. Their job description is to teach the kids. If I'm distancing myself from this situation, and then I'd say, listen, second, we're giving some type of government immunity to protect us and insulate us from these types of claims as well. I think both of those arguments will be hard to go forward with proving at court, but that may make a settlement a little bit longer to get to because they at least have that in their bag.
All right, Khalif, we appreciate your insight on this. We've got another topic to discuss with you coming up next hour.
Queen City News Plus. Just search Queen City News on your smart TV's app store.